There's a lot of discombobulation with this whole Kyle Rittenhouse verdict case and shit. So I'm not opposing anything. I'm not justifying anything. I'm just telling motherfuckers what it is. First and foremost, it is the law that counts, not our morals. It might be a whole bunch of laws and statutes you might not personally agree with, but nevertheless, they still govern our society. Not just this case, it's plenty of cases. Motherfuckers be like, what? What the fuck? How is this allowed to happen? Well, under law, in particular circumstances, it's technically not illegal. Something else I'd like to point out. This was not a Supreme Court case. This was a state case. We are all governed under the U.S. Constitution, under federal statutes and laws, but each state has its own constitution. There is shit that you can do in Wisconsin that you can't do in Pennsylvania or these other states. You feel what I'm saying? So if this same thing were to happen in another state, that motherfucker might just go to jail because they're not protected under that law. Under Wisconsin law, technically, Kyle was innocent or wasn't doing anything illegal. Furthermore, laws pertaining to murder differ depending on jurisdiction, meaning penalties and convictions fluctuate from state to state. Now, if you ask me, why did Kyle get off? Because it was a weak attempt towards prosecution. The prosecutor tried a bunch of first-degree charges. First degree insinuates premeditation, meaning he planned everything out and it was deliberate. If he was reacting to a protest that was random, how could he have planned out the threat that came towards him, which was what they had to prove? You feel what I'm saying? You can't prove that he planned to shoot motherfuckers that congregated randomly. You can't plan that. What? Because he had a gun? They're allowed to have guns. That doesn't mean he planned to shoot them. You can't prove that he planned to shoot people because he had a gun on him. He was legally allowed to have a gun. It was a stupid attempt. Prime example of why this was a weak attempt towards prosecution. The 6th count they tried to charge him with was possession of a dangerous weapon by a person under the age of 18. In Wisconsin, you're allowed to have a firearm as long as it's not concealed. I think 16 and above, it says. That's in their laws. Why would you try to charge him or prosecute him with that if in their laws he's clearly allowed to do that? Do you not know their laws? Wisconsin law? Ain't you a prosecutor of Wisconsin? Shouldn't you know your own fucking laws? How did he beat all the charges? They tried to first degree everything, which means they had to prove that this was premeditated and based off the fact that this was a reaction to a protest and the protest wasn't looked at to be threatening. You can't prove that he planned to shoot anybody because he was walking around with a gun. Okay, the whole gun thing, I already explained how that was legal, so that shouldn't even have been a fucking charge. The one charge got thrown out, and then 3 of the charges were the same thing. It just was 3 different situations. So all he had to beat was the one situation, and he could have clearly beat the other 2 because it was the same charge for the same shit. Now, if they tried to charge him with 2nd-degree murder, which means it wasn't premeditated, they might have had a case. Can't charge him with 3rd-degree murder because that only exists in 3 states, and Wisconsin ain't one of them. Pennsylvania's one of them. I can't remember the other 2. Now, I do see that it did say that the jury was allowed to deliberate against 2nd degree as well, but the case wasn't shaped around 2nd degree. It was shaped around 1st degree. So you can't shape a case around 1st degree murder charges and then tell the jury, oh yeah, 2nd degree is up for debate as well. You can pick that too. Like, shape the case around 2nd degree as well. You feel me?